The honourable member for Nanaimo Ladysmith.
Thank you, Mr. Speaker. The most important changes in life are often invisible at first. Seeds sprout underground before the first shoots appear. A ship that changes course by 1 degree makes no waves but ends up somewhere entirely different. A coastline can look unchanged for years while the tide quietly reshapes it grain by grain. On August 7, 2025, when the BC Supreme Court released the Cowichan Tribe's decision, nothing happened. No Canadian lost their home. Richmond continued to function. The Cowichan Tribes repeatedly said they never intended to interfere with private fee simple title. And yet, the judge decided, first, that the Cowichan have Aboriginal title to land in Richmond, and second, that Crown grant of fee simple in those lands unjustifiably infringes that title. The court did say that private fee simple interests remain valid, but only until such time as a court may determine otherwise, or the conflicting interests are otherwise resolved through negotiation. With that until, a seed was planted, Mr. Speaker. Homeowners are now aware that a court could determine otherwise, and many of them are nervous. And at paragraph 3543 of a very long decision, the judge added, and I quote, "I accept that a declaration of Aboriginal title may give rise to some uncertainty for the fee simple title holders, and it may have consequences for their interest in land." Within days, it became clear that uncertainty had taken root, and within weeks, the first sign of a growing set of complications became visible. When a person gets a mortgage, their home is the collateral for the loan. If the mortgager's title is uncertain, they're going to have a problem. When a person sells a property, they promise valid title. If the seller's title is uncertain, they're going to have a problem. Anyone who claims to understand the full implication of the Cowichan Tribe's decision at this point is fooling themselves, Mr. Speaker. We are now seeing transactions delayed, financing reconsidered, and investment decisions paused in British Columbia. The case has already reportedly tanked a $100 million deal and created complications with mortgage and property transactions. The BC Financial Services Authority is recommending independent legal advice before buying affected properties. Real estate agents are adding new clauses to purchase agreements across the province. Title insurers are reassessing risk. The Musqueam Agreement followed quickly on Cowichan Tribe's decision, adding additional uncertainty. Investors are skittish and wondering what is coming next. Uncertainty is undermining confidence in land-based collateral in BC. The decision is adding cost we can't afford and disrupting parts of BC's economy at a time when stability is badly needed. The problem, Mr. Speaker, is not that Canadians are unwilling to support reconciliation. In British Columbia, we desperately want to live in harmony. But anxiety creates strain, Mr. Speaker, and government failure to negotiate treaties that would have provided legal clarity before these issues reached a crisis point is dividing our communities. For years, these Liberals talked reconciliation, but dragged their feet on negotiation. They failed to negotiate a treaty with Cowichan Tribe, so they got sued and lost. Now ordinary Canadians are paying the price. Families trying to buy homes, Indigenous communities seeking certainty, municipalities planning infrastructure, and businesses deciding whether to invest in British Columbia face years of legal limbo. Despite their insistence that they are going to appeal the decision and make everything fine again, the Liberals have painted themselves into a legal corner. The Prime Minister admits that property rights are fundamental. The Parliamentary Secretary admits that there are potentially significant implications, including for property rights, that could extend across the country, Mr. Speaker. The Prime Minister and the Liberals say repeatedly that they will make all viable legal arguments. But here's the problem. Appeals are not do-overs, and the raise it or lose it principle is a core one of how our legal system works. You're not allowed to save some of your arguments for appeal, just in case you don't get what you want at trial. If you could, litigation would cost even more, and it would never end. My dad used to refer to this as the you snooze, you lose principle. Paragraph 2096 of the decision says that Canada initially pled extinguishment, but abandoned its reliance on this defense in its amended response to civil claim filed in November of 2018. In plain English, what that means is that the Liberal government told its lawyers not to argue that fee simple title is superior to all other forms of title, and those lawyers amended the court documents in 2018 to take the argument out. A lot of Canadians are wondering how that could have been allowed to happen. Well, we investigated, Mr. Speaker, and we found the government legal directive, still online, that strongly encourages admissions of liability and discourages defenses like extinguishment that would support fee simple title. It turns out that the one argument the government needed in a 513-day trial is the one they didn't make. And that means it isn't viable on appeal. Conservatives have repeatedly asked how the Prime Minister is going to win an appeal with an argument he isn't entitled to make. In response, we've been accused of misinformation, fear and misinformation, fear-mongering, spreading misinformation, and causing disruption to the economy of British Columbia, and worse. We are not fear-mongering, Mr. Speaker, nor are we spreading misinformation. I have just laid out the problem in plain English, and it is not unreasonable to want to understand how this government is going to deal with this very serious issue that is causing unsettling divisions among Canadians. Those divisions are not being caused by Conservatives, Mr. Speaker. They are being caused by a Liberal government that doesn't make all available arguments, hides their mistakes, and attacks anyone who asks them how they're going to fix it. British Columbians bought their homes in good faith. They are trying not to lose them in face of the rising cost of everything and an economic crisis already made worse by government. What is perhaps most frustrating for the homeowners that I talk to is that there will be no clarity on these issues anytime soon. We are staring down months, if not years, of litigation while the courts sort this out. The order itself has not been fully finalized. A 513-day judicial record still has to be assembled. Preliminary motions have to be heard before the appeal can start, including numerous intervenor applications and a motion to reopen the case by landowners who claim they should have been involved from the beginning. The Justice Minister has indicated that Canada is supporting that application, which will make the case drag on even longer if granted, and I can't help but wonder if they're doing so in part because reopening the trial might get them that actual do-over. This is one of those cases where the process has process, but we got here through a complete failure of political leadership. The government knew this decision was coming. They knew there were more court cases coming. They yielded the field 8 years ago. But they've avoided doing the hard work in that time of creating a clear legislative policy and framework around reconciliation, Aboriginal title, private property rights, and legal certainty. Instead, they left it all to the courts to be sorted out piecemeal through massive and voluminous constitutional litigation while they stack the court with activist judges. Long trials may work for lawyers billing by the hour, but it does not work for families trying to buy a home, businesses trying to invest, or First Nations trying to build a stable future. Reconciliation requires clarity, fairness, and predictability for everyone. We need a government that is willing to find real solutions instead of continually asking the courts to do their job for them. I hope that all members of this House will support our Opposition Day motion, and in particular, our call for a special multi-party committee to study all legal, constitutional, and political steps that can be taken to protect private property rights in Canada. Indigenous and non-Indigenous Canadians alike need us to work together to come up with solutions to government incompetence on this file. The ship needs to change course, Mr. Speaker, because it's currently headed for the rocks. Thank you.
Questions and comments. Question and comment. The Honourable Parliamentary Secretary, the Minister of Environment and Climate Change.
Thank you, Mr. Speaker, and I thank my colleague, who I have much respect for, from Nanaimo territory, for her speech. She did mention that this government failed to negotiate a treaty with the Cowichan tribes. However, the Chemainus tribe, who's a part of the Cowichan tribes, dropped out of the treaty process in 2014. Who was in government at the time in 2014? So I just want to ask, I mean, we tried to negotiate on this side. We go to court. these sorts of things happen. Then they criticize negotiations on government-to-government level. What are we supposed to do? What's their solution to either negotiating with First Nations or going to court? Because they're saying both don't work.
I'm a member for Nanaimo, Ladysmith.
I spoke about the negativity that comes across the aisle when we ask questions and raise issues, Mr. Speaker. Stephen Harper delivered the residential schools apology in this House. A Conservative government led by Prime Minister Stephen Harper created the Truth and Reconciliation Commission, which resolved hundreds of specific claims, extended human rights protections on reserve, and introduced reforms aimed at improving accountability and transparency for Indigenous communities. Were there disagreements? Absolutely. Were there tensions? Of course. But reconciliation is not advanced by pretending that nothing meaningful happened before 2015. Some of the most significant steps towards acknowledging historical wrongs and building new relationships with Indigenous people happened under Conservative governments. And when you ask what we want to do about it, we have proposed that all parties, that parties get together, that we form a special committee, and that we work on this together because we owe it to Canadians, Indigenous and non-Indigenous alike, to make progress on this file.
Questions and comments? The Honourable Member for Winnipeg Centre.
Thank you so much, Mr. Speaker, and I agree with my colleague that the Liberals have been sitting on this. And in terms of spreading disinformation and paranoia, I do agree with the Liberals on that, absolutely, and I would liken the same behavior that's being perpetrated by the Liberals. So it's like, I don't know why they're calling that name when they're doing exactly the same thing. But to my question, we know property rights are protected, but also constitutional rights, and that includes Section 35 of the Constitution, which affirms and recognizes that Aboriginal rights and title are not secondary rights. We've taken an oath of office, all of us in here as members of Parliament, to uphold the rule of law, and that means the Constitution. The Conservative motion that has been put forward suggests that we should not respect the Constitution. Now, I'm not just talking about the Conservatives. The Liberals are playing the same game. Does my honourable colleague respect her duty as a parliamentarian to respect and uphold our Constitution and the rule of law, yes or no?
The Honourable Member for Nanaimo, Ladysmith.
Mr. Speaker, I have to admit I'm confused by the honourable member's question. Of course, we respect the Constitution, and everything that I have stated and in this speech, there's nothing in it that suggests that I want to do anything other than uphold it. Our proposal is to create a special committee. It is to work together. It is to find a way through this. And the reason that I support that proposal is because I believe in reconciliation. I believe in creating certainty. It is important for all Canadians, and I hope that the member will work with us to move this forward in a way that is good for everyone. Thank you.
Questions and comments? The Honourable Member for Aurora Oak Ridges, Richmond Hill, about 35 seconds.
Thank you, Mr. Speaker, and I want to thank my esteemed colleague for that absolutely excellent speech. My question is simple, Mr. Speaker. Anytime we make a very thorough, good explanation, we ask questions of the government, we hear them get up and go back 15 years ago, 10 years ago, refer to other places, the other governments that were here, other prime ministers. Does she think it's an effective way or a responsible way for a government to respond to members of the opposition who have a right to question in this House, who have a right to try to make suggestions to make legislation better?
Member for Nanaimo, Ladysmith, about 40 seconds.
Thank you, Mr. Speaker. I mean, look, I tried to stick to some pretty boring, cold, hard legal facts in my speech. Unfortunately, this is a very complicated case. It has been made more complicated by litigation decisions that the government made in this particular case. It's been made more complicated by litigation directives that quite frankly, don't make sense to many Canadians. And if we're going to move forward on this, we really need to be thoughtful, we need to be collaborative, and we need to walk alongside Canadians of all kinds in negotiating real solutions to these problems.
Resuming debate, reprise.